All right, 7:33 here on this Tuesday, and it's time to answer some of your legal questions. And as always, we turn to Fox 26 Senior Legal Analyst Chris Tritico. Good morning to you, sir.
Good morning.
Let's get right into this. So we're going to begin with a question from Robert. He writes here, I purchased a house in 1995. My house was built with aluminum wires, which most houses were back then. In 2008, our furnace went out, and we were using small plug-in heaters. One of the heaters caused a fire at the plug-in in my dining room, and we were home and able to blow it out. I called my insurance, and after an inspection, they agreed to rewire the kitchen and dining room, not my other rooms, though, leaving my house with half aluminum and half copper wiring. On January 21st, my daughter plugged in a small space heater, and this happened again. The plug caught fire. My question here is, shouldn't the insurance have changed all of the electrical wiring the first time when this fire happened?
Robert, yes, is my answer. They should have the first time back in 2008. I don't know why they didn't, other than they're cheap. But yeah, they should have. It's too late now to go back on that old claim. The statute of limitations has expired on that. You can make a new claim now. You're going to have to pay a new deductible, but you can make a new claim now and probably get the rest of the house rewired this time. If they're cheap this time and say they're only going to replace one room, fight with them, argue with them, and you may have to hire the lawyer of your choice on this to get the whole house rewired. But it is unsafe. Everyone knows that aluminum wiring is unsafe, so force them to change the whole house. Good luck.
All right, let's turn to our next question this morning. It's from Jesse, who writes, I was given a personal loan from my company. I agreed to pay it back out of my check every 2 weeks. I had to sign a document stating that it would be taken out automatically from my payroll check. I also got a percentage from sales as commissions. This is in addition to my salary, but there is nothing stating that the funds are to come from my loan agreement contract that the owner and I signed. I'm not trying to get out of paying this back, but can the company take from my commissions to pay back the loan if there is already an agreement in place?
Well, Jesse, probably not, but you signed an agreement that they could take it out of your paycheck, and you didn't tell me if your commissions come in the paycheck that you get every 2 weeks, or if it's a different check. To me, you should be saying, what difference does it make which check it comes out of, as long as you pay the loan back? You know you're going to pay it back, and you know you have to pay it back, so what difference does it make which check it comes out of, as long as every 2 weeks you make the payment? And so I don't know what the difference is to you, but you can stand on principle if you want to and demand that it only come out of your paycheck if that's what you want to do. Good luck.
All right, we have one final question. It's from an anonymous viewer. This is a bit longer of a question here. This viewer writes, my apartment was damaged due to the freeze. The sprinklers burst and the water came into the unit, causing damage to the wall and flooring along with the apartment next to mine. They cut out big sections of the wall in one of the bedrooms and bathroom through to the next apartment. We can see into the other apartment and they can see into ours. When we asked the apartment manager how long this will take to fix, he just stated that's why we should have renter's insurance, and it can take several weeks. The neighbors were put into another apartment temporarily, but we have not been offered anything. In fact, we were told to buy something to cover the holes in the wall until they can be fixed. There was a big fan used to dry out the walls for a few days, which was using our electricity. Now, I understand I cannot hold back rent, but is there anything I can do? I do not have any extra money to move right now, or I would.
So I guess you're going to really get to know these neighbors, aren't you? Look, this is the weirdest thing I've ever heard. You don't have to have renter's insurance for your apartment to do the right thing here. And if they're going to cut a hole in the wall that goes through to your neighbor's bathroom and you can see into the other apartment, they need to move you, period. That's it. Or they need to cover it. It's not your responsibility to buy the covering to ensure that you have privacy in the apartment that you're renting. That's it, period. This is what's called a habitability issue, and your apartment is no longer habitable if you can see into your neighbor's home and they can see into yours. It's not habitable. Under Texas law, you can write them what's called a 10-day notice letter, and they demand that it be repaired in 10 days, or you can move. Now, you said you don't have the money to move, but that's what the legal remedy is for you. And you can leave that premises and rent a new apartment in 10 days if they haven't fixed this. And so write them that letter, send it certified mail so you have proof that you sent it, and if they don't do something, put you in a new apartment or do something, you can leave and get a new place. Good luck.
All right, and that was a crazy one for sure.
Nuts.
Wow. All right, as always, we appreciate you and your advice. If you want to send us any legal questions, just hop on our website, fox26houston.com. You can find all of Chris's segments under the Morning News tab. And as always, for specific information and advice, contact an attorney of your choice.